what promises to be a very interesting panel. First of all, of course, I'd like to thank also to the organizers, both for inviting me as well as such an interesting panel, and maybe first and foremost for putting judicial integrity actually as one of the subject areas to be covered by this conference specifically, to which I have a very direct interest in terms of my current professional responsibilities. But let me start with introducing the panel. So first, we have with us the Honorable Justice Bennett. He's a judge at the U.S. District Court for Maryland since 2003. He has been also the district attorney for Maryland. He has been in private practice. He also served, interestingly, I find that always very interesting, in the U.S. Army Reserve and and for the National Guard. And I think very relevant to the discussion here today, he has not only, of course, a long judicial and legal experience in the U.S. system, but has also been working extensively in Central and Eastern Europe, assisting those judiciaries in the developments of judicial reform efforts over the past decades. Then we have with us Ms. Linda Bashai, Dr. Linda Bashai, Director of Research, Evaluation and Learning at the American Bar Association Rule of Law Initiative. And as she just said, she was the very first intern of that very same initiative when it started, I think almost 3 decades ago. She has been a professor in actually teaching at multiple renowned universities, holds a PhD from the London School of Economics, and worked for the longer part of her career with the United States Institute of Peace, focusing on prevention of electoral violence, in particular in several African countries. And then we have with us Peter Ainsworth. He's a senior anti-corruption counsel at the Department of Justice here in the US, and has led multiple prosecutions against judges. So that's a very interesting, I think, perspective that he brings to this panel, and also served as an anti-corruption expert for the US government in various intergovernmental bodies, including our own at the United Nations in Vienna, to the UN Convention Against Corruption, as well as to the similar convention of the Organization of American States. Now, we will be focusing on judicial integrity as our main topic of discussion. And we want first to basically look a little bit together with the panelists at the problem itself as it represents itself in various countries across the globe. Then we will be starting to look at the various efforts that have been taken to strengthen judicial integrity, not only looking obviously at the prevention of corruption, but more generally also at other forms of misconduct. What has worked and why has it worked? And finally, we will be looking at what lessons can we draw from that, and what can technical assistance providers essentially take from this discussion and integrate into hopefully their programming as they move forward and try hopefully to have better impact. Now, as I said, maybe just before opening for the first question, I myself, my name is Oliver Stolper. I'm working for the United Nations Office on Drugs and Crime. I've been doing that since '99 in a whole variety of functions. But I've been always also working specifically on the topic of judicial integrity. I've had the pleasure to serve with the group that developed the Bangalore Principles on judicial conduct. And I'm now heading a program that actually has a specific component focusing on judicial integrity. And it tries, and I'm very grateful for one of the comments of the previous speakers in this previous panel about the importance of networking, because we try to create, actually to launch a global judicial integrity network, which should come into existence in early next year. So we will be probably touching upon this also a little bit. But maybe I should first take a step back and ask a question. I would like to ask the question to Linda, really on how big a problem corruption and other forms of misconduct are actually in the judiciary if we look at it globally. Do we have anything beyond perceptions that prove to us what is the evidence that there is actually corruption or misconduct in multiple judiciaries? And what are the most frequent and most pervasive forms that we can observe of judicial corruption or other forms of misconduct in your experience? Linda.
Thank you, Oliver. Thanks for letting me be here. I'm grateful to Just Track and to the Wilson Center. There's an interesting outcome when you do evidence-based surveys and studies of the perception of judicial corruption. The International Bar Association's Judicial Integrity Initiative did an interesting study recently, and they found that public perception almost very frequently overstates the level of corruption that they believe is present in their society. Because they'll say, I believe that there's a high level of judicial corruption, but if you ask them if they've had experience of any directly, they say no. Or if they have any examples that they can point to, and they don't. So that's an interesting outcome, and you have to wonder why that is. Why are people more likely to believe that there is judicial corruption than there may in fact be? And I think that expectations are a big part of it. I think that if the public does not trust the judiciary because it sees the judiciary as tainted or somehow colored with the brush of the weak system or the weak government and what they may perceive as a corrupt political system, then the judiciary won't have the public trust. And I think that's an important thing to keep in mind as we examine levels of judicial corruption. It is incredibly difficult to measure the actual instance because it's very sensitive. No one will self-report corruption. If you ask them, so have you engaged in corrupt behavior? You're not going to get that right answer. Obvious reasons. Even with a very private survey, people just aren't going to see themselves as corrupt. There will be all sorts of reasons why they do what they do, and an outsider would see it as corrupt, and an insider says this is the system, right? So you have to look at the whole system to analyze whether or not there is in fact corruption, and judicial corruption exists within the whole system. I would say that there is a correlation between particular types of pervasive corruption and the problems of the system. So there's a correlation between bribery as a form of corruption and the weak rule of law, lack of respect generally, lack of enforcement, not paying attention. So you got very little to lose if you're a judge in a system that's very weak and you don't have respect. So bribery seems like a pretty good option. You probably don't have the resources anyway, and so maybe it's not even bribery in your own mind. And then there's also the factor of undue political influence, where judges seem corrupt because they seem to be in the pockets of political leaders. And that can occur, interestingly, even where the rule of law is strong. So you can have a respect or an enforcement of judicial decisions, but also a high incidence or high belief in the incidence of political undue influence, which is an interesting distinction between bribery and political influence. For me, I'm not sure, maybe this is heresy to say on this panel, I'm not sure it's worth really trying to actually measure the incidence of corruption. Because what matters much more is that the health of the system be strong generally and that the public perception and trust in the judiciary is strong. I'll leave it at that. We can go from there.
It's very interesting. And I think also, especially one thing that resonates a lot with me is this huge, the gap between perceptions and actual experience. And it's very hard to predict how big that gap is. Just to give you one example from a survey that we conducted a couple of years ago, was that in South Africa, we did a court user survey, and we asked both the opinion standard question, do you believe there's corruption in your judicial system? And 50% of the respondents said yes. And then we also asked basically during the last 12 months, have you or a member of your family been approached basically in the context of the case that brought you today to the court for the payment of a bribe, not your family member, your lawyer. And literally out of the entire sample of several thousand people, we had one respondent that claimed that they had actually been confronted with a request for a bribe. Now, I have a lot of other examples where the perceptions and the actual experiences are much closer together. So the point I'm trying to make is very hard to predict. Just simply say you have high perceptions and therefore you also have high incidence. That's unfortunately not how it seems to be working. Moving on, and of course, bearing in mind the importance of judicial independence, which we had been discussing for the past 2 hours, who should hold judges accountable, in your opinion? And maybe we should start in this case actually with the judges themselves. So,
yes, I think that first of all, it's great to be here with the Just Track program. The last time I was with Joel Samuels, we were in Prague in Czech Republic, and it's a very great honor to be back here with this group, and I would be remiss if I didn't also note the great Wanda Rubianas, who's here in the audience, who coordinates with the International Judicial Relations Committee of the U.S. Judiciary. So it's nice to be back with my friends. In terms of who really controls the matter of corruption, I think that Linda's point about the matter of direct bribery is well taken. You don't necessarily have people coming forward saying I've paid a bribe or I've been solicited for a bribe, but even in the most corrupt cultures. But you do, the issue of public perception is obviously quite important. And I think that in terms of controlling that situation, I have found that the key word with me, I think, is transparency. Because, quite frankly, I'd be interested to hear what Peter has to say on this, but when I think about exactly how would a federal judge become corrupt in this country, I'd be mystified as to how he or she would go about it, because every May 1st, we have to submit over to the Administrative Office of the Courts the most detailed financial statement. And each May 1st, I not only have to report everything that's happened in my life financially, I have to report everything that's happened in my wife's life, which means every May 1st, we have to have a religious experience where my wife explains what she has or has not done with credit cards for the past 12 months. And every year it's the same conversation. She'll say, why do I have to do this? You're the judge, I'm not. And I'm like, because you are my spouse. And to the extent that you suddenly have a $27,000 balance on Bank of America and you no longer have the balance, someone's going to say, where did Mrs. Bennett get the $27,000 to pay off her credit card? They're entitled to know that. So the matter of financial disclosure and transparency, I think, is a great self-enforcement mechanism. And in the conversations I've had with our Eastern European colleagues, I have said, and usually it gets a nod of agreement with the judges, I've said if there's one thing legislative bodies and executive bodies around the world want to do is to control judicial bodies. So you don't have to push real hard to have the legislature, for example, say that judges have to make the following financial disclosures. But I always make the point that it is actually an arrow in their quiver, so to speak, because the minute that that process starts, I think it legitimizes their positions, and it causes them to have greater credibility with the public. When the public truly starts to realize that judges are required to disclose their financial situations, the sooner that happens, I think, it becomes a self-enforcing mechanism. And it can happen in not only the most developed countries, it can happen in countries that are still developing their legal systems. If they can adopt those kind of mechanisms early, it causes one to have, I think, greater confidence. And I'll just close my initial comments by noting that in one trip to Ukraine, a very delightful fellow was insistent that when we're traveling back into Odessa, that I see his dacha. And a state prosecutor, Peter, was with me when we went, and he just wanted us. It was a guy's thing. The women judges went one way with whatever, but the other prosecutor was a male, so this guy from Ukraine wanted us to see his dacha. And this was what we would call in the United States a McMansion, of about 6,000 square feet. There were 6 or 7 gentlemen from Armenia who were working in a construction crew building the house. The house overlooked the Black Sea. It'd be like having 2 or 3 acres at Cape Cod overlooking the Atlantic Ocean. And we're sitting out there having wine and cheese, and we're looking out over the Black Sea. And finally, the prosecutor mumbled to me when our host decided to change a bottle of wine. He looked at me and mumbled. He said, "Judge, what do you think about transparency?" And I said, I might have a little difficulty with the transparency of this. And both of us had the same reaction. We were like, he was a very delightful guy. We were like, where did he possibly get the money for, this was not where he was living. This is just his home out in the countryside. We never really got an answer for it, but I always had a little bit of level of discomfort after that about when I'd socialized with him, because I still, to this day, don't know where that money came from for the dacha that's overlooking the Black Sea. Well, I think a long-winded answer to your question is transparency, I think, can be key, because transparency can increase the level of public confidence. Transparency can, I think, cause public perception to gradually rise, and it can also cause people who perhaps have not behaved as they should to have a little bit of explaining to do exactly how their financial situation changed so much from one year to the next. So.
And I'm very glad. I think you're the first judge that seems to be a fan of the income and asset declaration system, which I'm trying to convince others. So I will certainly quote you, if I may,
Certainly can.
on future occasions.
Just don't talk to my wife about her credit cards. That's all.
Understood. Peter, maybe you want to give the external perspective, especially with the background of your experience.
Certainly. I think just to reflect back on the judge's Ukrainian experience, that state prosecutor was probably just jealous because he had a slightly smaller house. That's what was animating. Let me pick up where Judge Bennett left off, which is that, yes, transparency is enormous. And by the way, yes, the asset disclosure statement is where the prosecutor will begin in these kind of investigations. But importantly, I think there's a question of who's going to ask the questions. Who will ask the questions, and when does the court system police its own versus the external prosecutor and the U.S. model, the executive branch step in and exert power. I have a little story to tell you that I think illustrates this a little bit and really highlights some of the challenges. Down in the Southern District of Texas a few years ago, I prosecuted a sitting federal judge. But the story is more complicated than that, about how we got involved as a executive branch corruption prosecutor. How did I get involved? What happened was a young woman who worked in Judge Kent's room, she was a court clerk, complained to the judges, the judiciary, about sexual assault on the part of the judge directed at her, and several instances of it. The Fifth Circuit convened a judicial panel, took evidence, testimony, documents, and the three judges couldn't come to a conclusion. Judge Kent said it was consensual, and the court clerk said, no, not even close. Judge Kent was reprimanded by being given a week off with pay. The court clerk was livid, upset, so she went to the FBI. The FBI came to us. We did a full investigation that took close to a year and a half. And the long story short is Judge Kent pled guilty to obstructing justice in that the Fifth Circuit hearing, and also admitted in his statement of facts that he had sexually assaulted this woman several times. So, there are instances where, of course, the court system, in terms of independence, the principle of independence will police itself, ethical violations, things like that. But there are also, in a country like ours and most of the countries around the world that certainly adhere to the principle that nobody is above the law, there have to be some instances where an external enforcement mechanism is in place. And that's, I think the Judge Kent case illustrates that. Judge Kent, by the way, was a judge when he pled guilty, was a judge when he was sentenced. He was a judge when he reported to the Federal Correctional Unit in Massachusetts, and he only resigned after the House served him with the articles of impeachment. So another sort of interesting wrinkle if you tell that story to an to an international audience and tell it in the context of how do you assure independence. This is one of the perhaps absurd results, but nevertheless, I think it's a mechanism that works.
Thank you very much. Maybe we should be moving on as we have started now to look at a bit more broadly at conduct in general, not just corruption as such. In your experience, and maybe we should start again with Judge Bennett, what are the most effective ways to safeguard compliance with codes of conduct? And maybe also what can we as technical assistance providers basically learn from that experience, specifically in the US, that we can perhaps transfer into other countries?
I think the first thing is I was involved in a program over in Eastern Europe in which our hosts were preparing this very detailed code of conduct. And when it was my turn to speak, I held up the code of conduct, the canons of ethics. What are there, Peter? There are exactly 5, I think. There are 5 basic canons of ethics. And there's commentary, and it's a pamphlet, very readable. And I said, you can't possibly legislate over all types of codes of conduct. You need general principles by which you abide, and then you need to have an ability to try to check yourself out on those codes of conduct. And, for example, with the 5 canons of ethics for the code of conduct of U.S. judges, there are commentaries to that. The whole thing is maybe 40 pages in length, if that. And then in each circuit, we have essentially we have a judge whom we can call if we have any questions about ethical conduct. And there is always a wonderful fellow named Robert Daling, who's at the Administrative Office of the Courts, and Robert Daling is available for the most sophisticated issues in terms of whether or not one should recuse him or herself because of a situation that was attendant years ago. If you have any doubts, you should err on the side of caution on these issues. So I think that is the first thing I would note is in terms of a rather simplistic, not a very detailed, but a simplistic structure. And this is true. It can be very quickly adapted in any developing country. It takes us, we always forget how long it took for our judiciary to develop in this country. People forget that the building in which the United States Supreme Court sits was built in 1932. And it's rather symbolic that until I think it was 1932, the Supreme Court met in the basement of the Capitol. That was a structural statement of our government. It was in the basement of the legislative branch where the Supreme Court of the United States met until 1932. I think that we forget sometimes how long it took for our system to develop. And I think to the extent that we have those self-enforcing mechanisms, it's a good start. But I don't think we, picking up on what Peter was suggesting, and Linda, I think, addressed earlier, I don't think we can also, as we get into this area, overlook the importance of our institutions and the importance of our independent media. And I really want to make sure while I'm here in Washington today that I salute the media in this country. And we're going through a rather difficult time, obviously, but it's a very important institution. It needs to be respected. And the only way I can give it as a good example of this, Oliver, is when I was outside of Russia. I was outside of St. Petersburg in Russia, and we're driving back in after a Sunday afternoon for a day of meeting starting on Monday. And my host were prosecutors and judges, clearly no advocates, no private attorneys, but judges and prosecutors were driving back in. And we had a police escort, and one of the judges was having a glass of vodka in the car, and we're speeding on this green median strip, and the police car's got the siren going, and people are getting out of the way. And I was a little uncomfortable with it, and finally one of the judges said, "Richard, what's the matter?" And I had the translator, because I speak just, Yan Nimanoga Gavru Polski, just a little bit of Russian. I said, "Whoa," I said, what are you doing? And he said, "Well, judicial immunity, independence of the judiciary, American independence of the judiciary." I said, "We're not that independent." He said, "What do you mean?" I said, "We're independent with our decisions." But I said, good God. And I mean, I'm not kidding. This guy was moving along at 90 kilometers an hour, and they're moving in and out. The people are getting out of the way. And I said, there is not a judge in America that would sit and do this right now. He said, we'd be on the front page of the Washington Post the minute we got stopped. I said, I can't believe this. And he just said, we're immune from this. You have immunity as well. I said, I don't have immunity from that. I said, this is extraordinary. And I think it goes to, we can't ignore the self-policing mechanism, not only our own conduct, but the power of the American press. There's not a judge in America, in my opinion, coming into any major city that would conduct him or herself in that fashion and be potentially exposed to the headlines Monday morning on a drunk driving charge.
Okay, thank you very much. Linda, do you want to perhaps add to that?
Sure, I do, thanks. I do appreciate that Judge Bennett mentioned the role of the media, and I think it's absolutely critical. I would also point out that media needs to be well informed about how the judicial process works, because misinformed media don't do anyone any favors, and can contribute to a greater mistrust on the part of the general public. For me, I want to back up a little bit and talk about, again, the whole system. You might have guessed by now that I'm kind of a satellite thinker. And I like to back up and look at the whole picture. And for me, when we are looking at the end goal of being a transparent, accountable, and incorruptible judiciary, you have to start with law school. You have to start with how they get there. And getting in, you should not be able to bribe your way in. It should not be because of who your parents are or what role you play in the society and how friendly you are with the heads of government. You need to have a meritocratic and diverse selection mechanism. And then once you get through law school, you need to, the law school itself, you need to not be able to bribe your way to pass an exam. There needs to be an understanding that the judiciary is an honorable profession, that there is respect for it, and you have to cultivate this esprit de corps from the very beginning, so that by the time you get to the position of being a judge, you are responsible for the team, right? Anything you do is going to bring down your colleagues, and that's how self-policing works. You're going to get a lot of judgment from your fellow judges if you violate the norms. And I think that is more difficult, because it's not just a question of getting good law schools. The ABA supports law schools. We work with bar associations. We work with judicial associations. We help develop codes of conduct, and we soup to nuts, the whole process, and we work with it. But it's really the whole culture that has to fit in with it. I will just give an example of one of our programs that it lets you know what judges from other countries who come here and look at our system think and what strikes them. My team runs a program called IJET, International Judicial Education and Training. Thank you, State Department. And we work intensively with judges who come to us with carefully selected after having applied through a difficult process with a plan for a change in their system that they're trying to implement. And we carefully design a curriculum for them while they're in this country, usually for 4 weeks, which is quite long. It's quite intensive. They have mentors, judges or other legal professionals who are well informed about the particular area that they want to reform. And they come and they learn. And it's not always learning because we do everything right. Sometimes it's learning because, wow, don't do that. And the point is that it's a carefully curated experience for them, and we give them a lot of feedback, and we stay with them and do follow-up visits and evaluate how they're doing with their plans when we go back to their countries. We've had visitors from really diverse sets of countries so far: Nigeria, Bosnia, Kosovo, Croatia, Lebanon, Peru, and Kyrgyzstan, and currently now visited by Vietnamese judges. So it's quite interesting to hear their thoughts on what they see when they come. And on the corruption issues in particular, we have found that they are quite impressed, you'll be delighted to hear, by the financial disclosure requirement. They just regard the U.S. financial disclosure requirement as impressive and onerous and unbelievable. And they, in returning to reform their systems in their countries, we have tried to work with them to start small, because when you really have pervasive distrust or weak rule of law or weak institutions, it can be, I think, in my view, a mistake to try to go big. And unless you're in the process of a complete constitutional transformation, if you are scratching away at corruption where it's a pervasive problem, and all you've got are some committed judges, you have to be realistic. The committed judges are not going to change the system. But they can do small administrative things that start to demonstrate that they're committed and transparent, want to be transparent. So we've advised them to make administrative changes that don't require the control or acquiescence of the legislature, things in which the judiciary actually can self-police. And it helps them avoid whatever kinds of pressure the legislature might want to bring to bear to those changes. And we've also urged them to reach out to media or civil society in order to be able to publicize those small successes. Because when you are making steps to be transparent, the public has to know. And otherwise, the transparency isn't actually transparent. You may be releasing all your forms, but if no one knows where to find them, or if they're not in clear, easy language, or if if none of the watchdogs or media or civil society agencies are able to translate what those forms that are being released actually mean, because I'm sure I don't know how to make sense out of your financial disclosure statement.
Just clip on U.S. Judicial Watch, and it'll help you very easily.
Right. Well, that's exactly
Judicialwatch.com. You can find it all.
That's
There's
exactly
no
my
secrets.
point. We need Judicial Watch to help translate the transparent measures that are taking place.
Thank you very much, and in particular for making the point on the importance of education at the tertiary level, and then of course I might add also on specific judicial ethics training for incoming judges, and then of course continuing as they are in service. Two things that we're actually under the program that I was mentioning before are presently pursuing, both ethics training in law schools and in the universities in more general terms, as well as judicial ethics training, and there will be an e-learning tool that hopefully will become available. But I think more importantly, you made obviously the point that we need a comprehensive approach, and only a comprehensive approach, which also then I think caters for the flexibilities of context and so on, can have eventually success. But even as we are saying that, and I would actually fully agree with that statement, at the same time, it seems, or at least many people will argue that despite of decades of actually doing what we are doing, we don't seem to be having really that major of an impact. I mean, one sort of example from my own practice is that I've been working for a long time with the Nigerian judiciary, and I think we made some very good progress until sort of 2010. And then somehow the achievements that had been made with quite demonstrably reduced levels of bribery, for example, in the courts, in a more recent study that UNODC did with data from 2016, suggested that most of these gains had been lost in the meantime. At least so the survey seemed to suggest. So maybe a long-winded way of asking the question, basically, why is it that we have so little to show for our efforts? Peter, maybe you want to take this first, and we go to Linda.
Sure. I think that change comes slowly, I think is the simple answer. I was in Togo, a small French African country, a few years ago, and I was talking about this very topic, or at least the last panel's topic, which is judicial independence. This very intelligent investigative magistrate, came to me afterwards. He goes, "You have to go all over the country. You have to talk to every magistrate, because before you came here, we didn't know we were supposed to be independent. We thought that we were supposed to execute the orders of the president. That's the way it's viewed in some of our countries." So, I mean, I think we have these wonderful instruments like the UN Convention Against Corruption that says in very clear and certain terms, prosecutors need to be independent, judges need to be independent, but do the practitioners read it and do they understand it? And I think ultimately, I think Linda's absolutely right. Educating the outside world, the press, the public, absolutely important, but we also need to spend some time with these folks that are in the trenches. One more quick story. Right next door in Benin, we were doing a class with 5-6 different countries involved in French speakers, and A judge stands up and he goes, I want to tell you a story about my brother. He's sitting right here. He's ashamed to tell you the story, so I'll tell you the story. It turns out that the president was trying to frame an individual for murder. Actually said that this individual tried to poison him. And he even went so far as to give the poison to the FBI so that they could test the poison. FBI came back and said, yeah, that's poison, but we don't have any evidence that he's the guy who gave it to you. So this magistrate judge who was in my class was assigned the task of bringing the case. And the task could be framed as making sure that this guy goes to jail for poisoning the president. Well, he was a man of integrity, and he said, there's not sufficient evidence to tie the poison to the man. And in fact, the next thing he knew, he looked out the window, and there were gendarmes surrounding his house. He was under arrest. He was under house arrest. His passport was taken, and he was under guard for weeks until the judges union, and that they have judges unions in West Africa, decided to shut down the court system. And that happened for a few weeks, and finally the president called off his people. And our judge ran to the United States, and last I heard he was in North Carolina looking for asylum in the United States. But the point is that, apparently in this country it was not well enough known that a president shouldn't intimidate a judge when he's ruling on a case, especially when the president hasn't a direct interest in the case. The man who was accused of poisoning the president is now the current president of Benin. and the other fellow is long gone. But just a story about how sometimes the practitioners in different corners of the world don't fully appreciate the concepts that we grew up with.
Mm-hmm.
Perhaps, Oliver, can I pick up on
yes,
something
please.
Linda mentioned in addition to what Peter was just saying? Linda mentioned the importance of self-policing, and that sometimes that can be easily done in terms of rules or regulations adopted just by a judicial body. And I was talking to Joel Samuels during the break about the last time he and I had been together. We were in Prague addressing judicial corruption in Ukraine specifically, Joel. I think that was actually the title of the program. I think the title of the program was, how do you lessen? It was like, okay, there is corruption. How do you lessen it? Which I thought was a remarkable title to a program. It wasn't like, is there corruption? It was like, how do you lessen it? But the New York Times had an article on Sunday that really caught my attention, and Linda's comment about self-policing really answered a thought I had. It was just on Sunday's issue of the New York Times, there was the arrest of an individual named Gennady Kapkanov. Kapkanov is 33 years old. He's a Russian-born Ukrainian hacker. And he was under investigation by both German, Ukrainian, and American authorities for many years on charges of cybercrime and for stealing more than $100 million in an international ring of cybercrime. And after a 4-year investigation, he was arrested in the town of Poltava in Ukraine, and was arrested and came before a Ukrainian judge. And the next day, that judge released him on bail, said he had to be released, and he's now gone and has left the country. Now that caused me to think, how does that happen? That I thought, there may be some judges in America, and Peter, you can correct me on this, but I don't know that there's any federal judge or federal or state judge in America that would not be subject to some type of interlocutory appeal by a prosecutor or something when one judge says, no, he can leave the courtroom, he's free. I'm thinking, how did Ukraine, picking up on Linda's point about self-policing, how did Ukraine not at least have, after all the efforts that have been made over the years, have some process whereby a prosecutor would have a right to appeal that decision for at least 24, 48, 72 hours, could go to an appellate judge and say, we appeal the order of this judge ordering that this man be released. And apparently they've not. Apparently that judge had the power to order Kapkanov immediately released, and they had no choice. He was immediately released, and He's gone. And more than a few people, I think, in Ukraine probably presume there's just the corrupt Ukrainian judiciary and somebody got paid somewhere, because there was a lot of money involved here, and the man is gone. As quickly as he was released, he's now gone, according to the New York Times on Sunday. So part of it may be the matter of institutional frameworks to try to have even developing judicial bodies have some mechanism whereby one judge cannot make that kind of decision. And I'm hard-pressed to think that prosecutors, and you know better than any, Peter, I mean, tough to think most state and federal prosecutors have some right to go upstairs pretty quickly and say, wait a minute, we'd like to, the judge has to recognize there's a right to go up to the appellate court of some sort, I would think. So,
if I could say just a word that also raises an interesting question of the appellate court's ability to review a district court or trial court, court of first instance, as they often say in Europe, their decisions, and then the issue becomes, can we look beyond the decision to perhaps the motive and perhaps the corrupt motive? All of these are very big questions.
Linda, and maybe also on the issue, what lessons can we draw basically from both the lessons learned as well as maybe some of the successes, if you have any to tell us about?
Sure. I was going to tell you about some failures first, but
Please start with the failures.
because I know Just Track likes us to talk about failure. But let me actually just make a little observation to Judge Bennett's story about the Ukrainian case. It might, I don't know Ukraine well enough, but in other experiences I've had, my gut tells me that prosecutor probably knew that would happen. Do you know, it's systemic. This is not a shock. And he probably also knew what would happen if he tried to appeal. Do you know what? That's how it works. It's
And he may have gotten a piece of it too.
Yeah, he may have gotten a piece of it. That wouldn't surprise me at all. So yes, you're right, and yes, it will not continue to, it will not change. I will talk about why all this work, all these years, all this money, all this effort, and why haven't we fixed the world, right? Well, part of it is that exactly what we've been saying all morning. These are big changes. They're systemic. They're institutional. They require many actors to all play on the same page and pull in the same direction. When you're talking about, and Nigeria is a perfect case of this, where just about everybody has come to feel that this is a normal part of how business is done. And then it's not even clear what is corruption when it's so systemic. So it's incredibly difficult to try to build the mechanisms that hold those actors accountable, and also the mechanisms that make things transparent, and also the esprit, the pride, the honor, the dignity of the position that I think is maybe even the strongest incentive for those who have reached high office. So I think, from our perspective, the failures have been maybe a little too eager to get in and help, and not taking and I think now we know that if we don't have legitimate, extensive, demonstrated political will in a country to make systemic changes, then systemic changes aren't going to be made. Now, if their judges come to us and they're a small group of committed high court judges in a country who want to make a change, we can help and should help them make the change just within the institutional controls they have. But we shouldn't fool ourselves that somehow corruption's just going to go away. And in some cases, I think we need to be careful that we are not putting members of the judiciary at life risk by telling them to be incorruptible in systems where their lives could actually be at risk. And it's, of course, a choice they need to make. Those are the worst systems. I think most systems are much more, loosey-goosey, much like the case that Judge Bennett just described. So I think having a commitment to not doing the work unless the work can be done is one mistake we are getting out of now, one failure that we're starting to learn from and overcome. We've been in places where we thought we were going to go do a major law reform program, and we invested time and effort and then weren't able to do it, just because all of a sudden nobody was returning our calls, or suddenly getting the cold shoulder, right? And we're like, wait, I thought you wanted this. I think we just need to develop indicators and thoughtfulness and process before we really invest deeply. And that goes for donors. I mean, it's not just the ABA once it gets the money and tries to run off and spend it. I think USG and other donors need to think carefully about what it is possible to do and not request the impossible. Again, that might be heresy to say on this panel, but I'll say it anyway. I have an interesting story from this morning's paper. I'm also a newspaper reader, avid, that really struck me. And as I read it, it's not about judges, but as I read it, it struck me that it might be relevant for this panel. There's apparently a police officer, a police commander in a small town in the Philippines, who, you must have read it too, who is directing his team not to kill. He's like, we're doing this by the book. We're bringing them in. We're putting them in jail. That's how we're going to do the drug problem. And he's successful. He's making it. No one is being killed in his district. And the fact that he's able and willing to do this in an atmosphere of what looks increasingly like lawlessness, to the point where the prosecutor of the International Criminal Court is thinking about investigating, is nothing short of phenomenal. And I was especially pleased to catch in the body of the article that this gentleman had been trained by the FBI, and that their ethic of no shortcuts, by the book, follow the rules, had really sunk in. And I thought, okay, sometimes it does work. Now, I don't think that's a great program model to assume you can make those kinds of changes in any broad sense. This is a unique and amazing individual, and we can't count on unique and amazing individuals for the success of our efforts. But it does tell you that that well-placed, committed individuals can make a significant difference, and it tells you that inculcating that pride and honor of the office and the responsibility of the office and its impact is something that can really make a difference. And I think that applies to judges as well as to other parts of the whole law enforcement cycle.
Excellent. Thank you so much. I think we should start to move also to open up a little bit for questions. We have addressed, especially with the latest comment from you, Linda, thank you very much. Also the issue what donors could perhaps do differently. I think from my side, just two comments. While it is absolutely true that we have been on law and judicial reform for a long time, programs that are actually specifically focusing or even have a subcomponent that focus on judicial integrity are still rare. So it's not actually so true that we have been expending massive efforts in that sense. But I think we have been actually, perhaps it's been always easier to do an IT reform or a procedural reform or to fix a law than to discuss with judges about corruption in the judiciary, obviously, and it's not as a surprise. But I think we should not make the mistake that thinking that we have been doing all of this work and so little to show for it. The second point, which I think is very important, is that, and that picks up on something that Linda just said, that and I don't have a solution for that, but certainly the project structure as things work at the moment, where we have like a maximum 3, maybe 5 years sort of horizon, and then we put in certain objectives, and even if our counterparts in the countries agree with those, they are subject to political changes, to realities. Basically, you have a good Chief Justice that wants to work with you, then you have a new Chief Justice who doesn't want to work with you. So these kind of things they can be it's very hard to cater for these changes with the present approach to basically development projects in general. And I think in particular with topics like such as integrity and anti-corruption, they really play out very negatively for the simple reason because it is such a politicized subject area. So it needs a different approach basically than what we I think have been doing with other in other fields, and maybe with some level of success. Anyway, I think at this stage we should a little bit open up and hear from you questions to the panelists. If you can, please specify to who you ask the questions. Otherwise, I think we do it by self-assigning. So the floor is open. That was quick, please.
Yes. Hi. This question is for all four of you. I'm Jade Wu, and I was on a rule of law program in Afghanistan. And this question focuses on what happens when the concepts of necessity and temptations get blurred. One of the things that really bothered me in Afghanistan was when I was working with the judges and the prosecutors there, the prosecutors were really outspoken about not getting paid on time by their own employer. And they were looking at me as in the American, the US, what were we gonna do about it? And one of them, actually several of them on different occasions, told me that they took secondary jobs to support their families. And I quickly saw that because they were not getting paid, they were very tempted to creative ways of getting paid. And the judges themselves were troubled too, but they were very reticent to talk about their wages and how it was coming to them and whether it was coming to them. So my question to all of you is, in your travels abroad, in your programs abroad, have you come across this problem when temptation and necessity crosses each other? And what has been done about it, especially when the problem is beyond the judge, when he has to live, and it's an infrastructure problem? And should we, the US, be involved with injecting income into their bank accounts?
I've actually dealt with that if I can. That's an excellent question, and it's ironic. I had almost that identical discussion with Joel Samuels during the break, in that we had, I don't mean to be picking on Ukraine today, it's just that they're on my mind, but this was certainly, I will tell Judge Inga Torji, it would certainly not happen in Georgia, obviously, but this is a situation in Ukraine. We had a group of Ukrainian judges here since I've last seen Joel in April of 2016, and I managed to set up a meeting with a member of the Senate Foreign Relations Committee. And the U.S. Senator was nice enough to have us meet in the Senate Foreign Relations Committee room right in the Capitol. And all the judges from Ukraine were very honored. And we're having a very blunt conversation on this very topic. And finally, one of the judges, who had increasingly been more receptive to the program, but was a little cynical when we started, and he really came around by the end of the week, he literally almost uttered the same words that you just used in your question. He said, "I have to feed my family." And the senator picked up on that, and I thought that might be the most candid comment that I've ever heard in all the years I've been doing this, last 10 or 11 years with Wanda Rubianis and all these delegations that come through. He was being very honest, and the senator responded saying, "I hear you." And then I finally interjected, maybe all the money that goes to some of these countries, picking up on what Linda was saying earlier, needs to be totally focused. And the senator said, how about if some of these aid grants go only to judicial salaries? And the judge was like, why not? When you have grants and aid, when you put money in, when you have these USAID programs and all the effort, maybe some of it has to be absolutely focused upon paying prosecutors and paying judges, and so they can get realistic salaries. Because in some countries, I don't know about Afghanistan, I've not been there, in some countries it's totally unrealistic in terms of what the pay structure is. And so with all of the efforts at the institutional reforms, it falls, as you say, in the face of necessity. And that one judge saying, I have to feed my family, that was the most positive result we had all week of that. And I don't know what has come of it from the point of view of that particular U.S. senator, but there was some effort to say we need to target these dollars better and have some control over where the aid is going to address that problem directly. That's my own experience in response to your question.
Linda?
Yeah, I have a little response. I've been in Afghanistan and met with some of the judges there, and also with academics, and that is a pervasive problem, the lack of salaries for urban professionals, and for them to be able to be professional and to do their jobs. I agree with Judge Bennett that is something we should prioritize quickly in order to stand up and strengthen institutions that are necessary for these countries that are emerging out of some pretty significant conflict to stabilize. I don't think we've been doing it particularly well. But I also caution that unless you also raise the awareness and understanding and build civil society advocacy for and on behalf of judges and protecting their salaries and their independence and the transparency of the process, then it's an unsustainable result. Because are we going to be there paying their salaries forever? So we don't want to put ourselves into that situation where we've created a completely dependent client state. I think we don't. And so I have caution. I mean, I agree that that's a very significant problem. And we also exacerbate it, in my experience in Afghanistan in particular, we've exacerbated the problem by cherry picking off the most literate, best, highest functioning professionals into our own institutions, right? All of the NGOs and international organizations and our own embassies. And, you know, we want the English speakers, we want the college graduates, and we pay them better. So I wouldn't be surprised if there are some judges working for us not doing judicial work, because we do that. And I've long thought that that's a really significant problem that we have in the places where we have a major U.S. presence. And I would advocate that we pay close attention to how we staff our missions and our offices and our programs abroad, because we are taking away the professionals without thinking about it.
You want to also?
Yeah, let me just, I'll play the prosecutor, the skeptic. I had a conversation like our colleagues' conversation in Afghanistan, in Armenia a few years ago, and these guys were saying, I don't get paid, we need more money, things like that. I look out, and as they're saying this, I looked out of the second story Marriott window at the parking lot. And the vehicles in the parking lot that they had come to the conference in were probably nicer than what many of us drive. So, I mean, who's going to determine how much is enough? Who's going to, it becomes a difficult development project. I certainly am not going to argue that prosecutors don't deserve raises. I think they do. And in many of the countries I go to, judges and prosecutors are underpaid, but I think this is a difficult issue because one of the reasons why they're underpaid or not getting their paycheck on time, it sounds like your example was, is because there's corruption elsewhere in the system. And so ultimately, it's the pervasiveness of it and the fact that those in power actually have the ready access to the money available is part of the problem. Perhaps the salary structure is not necessarily part of it. So just skepticism is all I'm advocating here.
And I would like to add to the skepticism. Simply, I mean, there are probably some very unique situations, sort of like really immediate post-conflict, and Afghanistan may very well fall into that category, type of situations where really there is no state that basically provides for the judges. Like in the DRC, I was confronted with that. There was simply no payment happening, so the judges would not would not leave the capital in order to go to their postings because there was nothing out there for them to go to, and no support structure basically to ensure that they would receive pay and be able to essentially fulfill their functions. But apart from those, I would completely agree. There's more downsides with the approach than upsides, and I think the biggest downside for me would be the moment that the donors start to basically chip on salaries. You essentially take away the pressure for the situation to change because the money theoretically is there. There is a government budget, there's a government income, and that income needs to be distributed across a public sector that is hopefully commensurate basically to whatever the state can afford for itself. By basically chipping in, we're creating a situation where we already know that essentially we're taking away the incentive for that to happen, and eventually probably will just create a situation where the corruption is allowed to breed even longer in the rest of the government when it should be addressed heads on. But it certainly, I can understand. I mean, also you and ODC, we funded an anti-drugs unit in Tajikistan some years back. Not a good experience, also for your own integrity standards, because very often, like, you wonder where all of that money goes to unless you physically, personally pay it out to the judge or the officer themselves. So my voice is saying goodbye, so I give you the floor, please.
Can I just offer, Oliver, can I just follow up with one comment on that? I think I might have a little bit of a dissenting opinion up here on this. I don't know how much time we have. Okay, listen, I don't mean, I'm going to tell me as a culture in terms of some of these issues. The New York Times article on Sunday mentioned that Ukraine, in many ways, can be seen to be the epicenter between autocratic governments in the East and Western democratic traditions, and that they tend to be clashing there, that there are countries that were former Soviet republics and dominated by communist governments, which I think have come miles since 1991 and the fall of communism. But we forget that we're 240 years into our experience, and there are enormous pressures on these countries. And I, for one, would say, in response to Linda's, Peter's concern, even your concern, I, for one, would say that given the amount of money we have in foreign aid in this country to many places around the world that continue in perpetuity as part of our budget, I'd have to say that I would have a stronger level of comfort in response to the question earlier about being able to focus on specific aid for prosecutors and judges, and eventually their culture will catch up with it perhaps, but if it takes a while, then it'll take a while. But there needs to be a real effort to help strengthen very quickly the judicial branches and the independence of prosecutors. I mean, the reality is the reason federal judges have lifetime appointment and the reason judges in this country cannot have their salaries ever diminished is because the King of England had a very easy way of controlling the judiciary. He did not try to dictate what the opinion should be in the colonies of America. He just didn't pay them. And so when this country was founded, one of the first things was in Article 3 was to say that you get lifetime appointment or on good behavior, lifetime appointment, and the salary of a federal judge cannot be reduced. That was only in the federal system, not the state system. And there were years and years and years throughout the development of America where the state systems were not quite as so attuned in terms of pay, political muscle, so to speak, on the judiciary. We have our own ghost and our own past in parts of this country in terms of how we dealt with individual rights. So that was done at the get-go in this country when it came to the federal judiciary because of that very reason. So I don't know that we have the luxury of time when it comes to the matter of what's developing in certain parts of the world. I mean, the picture is not, I was thinking coming over here this morning, when I think that, I was looking at the bio you have of me, and I was in Turkey. Well, that's going great. Erdogan has basically arrested judges, and judges have been sent out in traffic court in different places, so they haven't been arrested. So Turkey has not been a real success. And that I was in Turkey, and then I look at what the situation has been in Ukraine and think about what I read in the paper on Sunday morning in the New York Times, and that hasn't been a great success. Estonia already had its own traditions, and that is a success, but it already had its own traditions. Bulgaria is making efforts, but I'm thinking we're like going 3 steps forward, 2 steps back, and we have the political dynamic in certain parts of the world where we have to recognize that these countries that want to follow our Western traditions, we need focus upon what we're trying to do. So I must say that if I could control what's going on in Capitol Hill today, I'd say, I'll tell you what, just try to help judges in these countries, get them paid, get prosecutors paid, give them the ability to be independent, and let's see what happens. Let's not expect to have it happen in 3 or 4 years overnight. That's my own thoughts. So.
Thank you very much. It's good to hear that from somebody who can say it with the authority that you can say it with. Please.
In Georgia, we also have financial disclosure rules for judges, but I don't think it's worse when it goes to accuracy of information reported by judges. And I don't also observe well-developed methodology or rules which based on what these reports are evaluated, analyzed by somebody, and then something should be done in case judges' reports are not accurate and very inaccurate in many instances. What is your experience? I mean, what kind of rules, how judges' reportings are evaluated? And I wanted also to echo to Linda about perception of corruption. Of course, you can measure only perception of corruption because we don't have victims in this crime, right? You have both sides are commit crimes. So I don't know where it came from. Maybe it's really very good rule to consider those who give bribes also they commit crimes. There is. That shouldn't be this way. So we discourage them to give bribes to public officials through this way, and we consider them also criminals, right, which participate in this negotiation. But what do we, to some extent, at this point of development, change this rule? And don't consider these people, especially when it goes to judiciary, that they are also defendants. Let's consider them victims. I don't know. It just came to my mind out of nowhere. Maybe it has no very good grounds behind it, but maybe it helps then to report these crimes and to reveal this number of real corruption level in countries. Thank you.
Okay. Just checking if there's any other questions, because then maybe we take the 3 questions and then we answer them all together. There are 2.
Yeah, thanks. My name is Christopher Russell, and the panel today has noted the importance of transparency a lot, and particularly in the case of financial disclosure. My question is how public documentation, such as the availability of decisions, argument transcripts, even filings and charges, might impact the integrity of the judiciary and public perception. And my experience in researching anti-corruption cases in Ukraine this last year was made much more difficult due to a void in those types of public documents. And I recall interviewing a special anti-corruption prosecutor in Kyiv about the lack of this public documentation and asking him if there were any laws that prohibited this disclosure of parties being charged, et cetera. He couldn't really point to any.
Okay, thank you very much. And the gentleman, no? Okay, good. Then we start off with those 2 questions. Maybe Justice Bennett, you want to?
You want to go with the first question?
Okay, with the survey question. Or the
survey question. Right.
The survey question. Well, that's Linda.
Yeah. I think that there are 2 important responses to the difficulty of really pinning down bribery in particular. One is, and your point about the accuracy of what is made transparent is critical. So the one response is that what I mentioned earlier, watchdog and civil society groups, the judicial watch types of groups that make it their business. And I think that I've thought this for a long time in other contexts, not just judicial ones. Civil society organizations, maybe the word watchdog doesn't serve them well. I think it's important for them to see themselves as responsible parts of a functioning democracy, not just the bête noire, the pests of officials or judges or any other public people. I think it's important for them to see that they're playing a role with responsibility, and in fact, that they are making it better for the honest actors. So I'd like to promote the idea that they're not watchdogs in the sense that they will bite. They're watchdogs in the sense that they will protect, because the better their work is done and received, the more the reputation of the organizations that they are watching is elevated. So there need to be civil groups that have that skill and have that commitment and make that their mission, that they will analyze those public documents and publicize them and let the citizens know. It's the citizens' right to know. There is no transparency if what's out there isn't fully understandable. And so that would be my answer on the accuracy of the financial reporting. On the offering of the bribes, I think you make a really good point that it's hard to catch because everybody goes away happy in some sense. And I think it's very important to make the offense not just criminal but social. You are breaking our institution by bribing our judges. You are wrecking our country by bribing our judges. This is a social crime. It's not just a technical crime like I stole something. It's a crime on the system. It's a crime on the society. And I think that there's something to that. I don't know that actually getting it written into the books is going to make change the behavior, because you'll still have a hard time catching it. But it might offer the protection to the judge who is being offered the bribe, that they will have that incentive only if they've already felt that pride and that honor themselves. If they are already feeling that they have a duty to be accountable, and that they are in an accountable and transparent institution that they will be letting down, then that's where your incentive really comes from. It has to be very social. It can't be single.
And if I can just weigh in with a law enforcement perspective here, this isn't obvious to people who work outside of this arena, but really all of these countries need to develop mechanisms to allow a judge to come forward and to allow a prosecutor and an investigator to fully investigate the allegation, protecting his or her identity during the course of that investigation, and only bring a case when the evidence has been collected, because people aren't going to show up, not going to make a phone call. I had a case, actually, we worked it. It was a lot of fun. It was the richest lawyer in all of the United States, down in Mississippi, was trying to bribe judges. We had a very courageous judge who picked up the phone as soon as the first conversation occurred, and he said, "I'm not sure, but I think this guy's trying to bribe me." We did an effective, proactive investigation, made tape recordings of the dirty conversations, the corrupt conversations, and the judge is a hero now. And Dickie Scruggs went to jail for 7 years. So the way that I think your point is very well taken, but we have to learn how to protect these people who are going to report. I told that story in Albania a few years ago. A judge looked at me. She was horrified. She said, I can't do that. I'd be on the phone all the time." She said 50% of the litigants in my courts offer me something to rule in their favor. So part of the esoteric angle here is to protect judges and protect other people by developing sophisticated and important mechanisms to collect compelling evidence that will ultimately change the view of the public when they hear this evidence in court. Dickie Scruggs actually pled guilty in spite of all of his money because we had some wonderful tapes. So,
I think dovetailing here, and well as getting to the second question, I think you mentioned Ukraine and the documentation and how does one actually find the documents that have been filed. It leads me to a discussion, I guess was in December, when I was in Kiev at a conference, and I mentioned that at the last Just Track program I was in, when I mentioned meeting with Joel Samuels, Joel, we were talking, we had that great blogger from Ukraine. He was like, Just Track not only had government officials, but they had, apparently was the leading blogger in Ukraine. And the guy spoke up and finally said, looked across the aisle, if I recall, across the table at the other guy that was head of the state information system, and he said, "You're here because you work for the state." He says, "I'm here because I have 3 million people that follow my blog." And I thought, wow, that's pretty powerful. It's pretty accurate, too. And he said, "That's why they've invited me here, because I have a blog and people follow my blog." And I mentioned that at the conference in Kiev in December when I said, then someone said, "Well, sometimes there's state control of information, this and that." And I finally said, picking up on the matter of transparency and perhaps countries that don't have as much time to institutionalize the things that Linda and Peter are talking about, is we ended the meeting before dinner that night, getting back to think what you're suggesting. I said, "I'm going to give you a word. It's a great word in America. Everybody understands it." He said, "What's the word?" I said, "Leak." And the guy's face lit up. He says, "Leak." I said, "People leak in America all the time." I said, "People have documents and they're document leaks, and they're Washington Post reporters and New York Times reporters, and they get information and they have privileges." I said, when all is lost and you feel like you're really up against a wall, I said, "Don't quote me on this." And by the way, I hope nobody quotes me here. But I just said, you can leak. Unless they're violating the law, you can leak. And I said, there's no law that you as a private citizen can't leak. I said, you have access to information and you want to get it to a blog and have someone say, "Has anyone noticed why Judge Andropov over here is driving a Mercedes and has a huge house in the countryside? Where did he get that money?" throw it out there. I said, I'm not saying that's the ultimate answer, and if you can't find the documentation for financial disclosure, that's not the ultimate answer, but given what perhaps some have sensed is my recognition, I think that there's a little bit of urgency that has to be attendant to all these discussions in terms of what's going on around the world right now. This guy seemed mollified. He said leak. He didn't speak much English. He went leak, leak. It's called leak. And he was, he said, I got it. So that's my thought, picking up both here as well as your question earlier.
Another question here, please.
Yes, I'm Kathy Stein, and I'm an administrative judge at the Environmental Protection Agency, and I do a lot of training of judges on environment around the world, and recently got back from training Supreme Court judges in Cambodia on the environment. And a lot of the principles that we emphasize are basic rule of law principles in the training, and I was curious, given the state of Cambodia's development and political situation, whether others on the panel had had an opportunity to work with the Cambodian judiciary, and whether you're seeing some of the kinds of issues that you've been describing here this morning.
No, I've not had the privilege of working with the Cambodians. I don't know that we've had. I'm not sure in terms of the Open World Program, which has brought some of them over through the Open World Program of the Library of Congress, but I myself have not really worked with the Cambodian judges or Southeast Asian judges.
Yeah, to my knowledge, we have programs in Cambodia, but I don't believe that they're focused on judges, although I could look into it and get back to you.
That's okay, I'm just curious.
Yeah.
Sure.
I mean,
Peter?
it really is an interesting time.
Yeah, and I've never been to Cambodia, and please don't suggest it to anybody above me, because I fly enough as it is.
No, I think that's not fair. I've been to Cambodia, but it's about 20 years ago, so I certainly not. But we have somebody who knows, actually. So Stephen, please, can you help us with that question?
I'm happy to pitch in a little bit. So I worked on a USAID project for about 6.5 years in Cambodia. It was, excuse me, it was focused a lot on trying to strengthen the judiciary. And I'll give an example of one of the challenges with Cambodia. And I think this is generalizable a little bit. And it has to do with the culture. And I know we've touched upon this a little bit, but many people will say things like ethics and corruption are not a universal trait, and that it's dependent upon culture, and we're trying to sort of impose a somewhat formalistic Western design. So here's the example. Early on in my time in Cambodia, we were assisting a group of legal aid folks, lawyers, who were representing this group of peasants who lived on an island right next to the downtown area of Phnom Penh, the capital. And these people were being evicted because they didn't have formal land rights. So they were being evicted by developers, and they were going to be sent off to the outskirts of Phnom Penh. And the legal aid representatives could not stop that eviction, but they were able to get some form of compensation. Was it just? No, but it was something. And the settlement was happy for everybody. And these very poor peasants, after the settlement was completed, wanted to give appreciation to the judge. And this appreciation was, in fact, a payment. And we tried to, direct that to some charitable causes, and it worked out okay. But it showed how deeply ingrained the idea of appreciation is in Cambodian society. Nobody in an official capacity does anything for you without some form of appreciation moving in the other direction. And it's often been explained to me in Cambodia that this is just the grease that lubricates all human interaction in Cambodian society for millennia. And here we are coming with anti-corruption rules and ethics codes, and those are working against it. And so it's a powerful cultural challenge that we had to deal with. I know Cambodia's not unique. There's bakshish throughout the Middle East. There are other terms in Latin America for it. Perhaps the panel could talk a little bit about the role of culture and whether or not this is being culturally insensitive by trying to impose our Western formalistic values.
Well, before asking the other panelists to chip in, I mean, from my very personal experience, it's certainly true that certain cultural norms are perhaps lend themselves more than to be also abused for more sinister, corrupt transactions. There's no doubt about that. But I also think, at least from all the survey work that we have been doing over the years, that there's a growing sort of understanding that certainly corruption in the form of bribery is unacceptable, and no matter in which culture you or in which geographical context you go, you will see that, like, for example, in the Nigerian case, I cite that because I spent quite a lot of time in that country. While basically 50% of Nigerians are on an annual basis confronted with requests for bribery, not just in the judiciary in general, and about 30% of them are actually paying, they still, more than 80% absolutely agree that bribery is completely unacceptable. It is not an issue of basically, they pay essentially because they don't feel, first of all, they don't feel themselves as offenders, because in most cases they pay for something for which they have anyway a right. Like, for example, in the judicial system, you typically pay for speed, not for the outcome. The speed is essentially not, is a right, so to speak, of the plaintiff. And in that sense, they don't feel that they are actually violating the law. They feel basically that they're being de facto extorted in order to have a decision in a reasonable time frame, and they need to pay in order for that to make it happen. And that's also why in the surveys, they're actually very open about speaking about that. And at least in that specific part of the world, you don't have a problem getting actually an honest or relatively honest survey response. The issue is, I think, overall, we are more and more coming together in a globalized fashion. It was possible for judges from all over the world to agree on the Bangalore principles as their guiding principles. So in a sense, while there is certainly still these type of cultural sort of like contexts, I think it would be more interesting whether the judge thought it was okay to receive the bribe, and not so much of whether some probably not very much educated, underprivileged person felt that it was obliged to pay a gratification of sorts. But any other things?
Yeah, so I've never brought a bribery case where some element of the defense wasn't, we're friends. I was just showing my gratitude, my friendship to this person. And now maybe that's true. If I would invite all of you to follow the Menendez case, which is actually happening right now. And in fact, that is the defense. I believe it's Abby Lowell is saying this. These guys were close. They're friends. The point is that we in our, and virtually every other of the 170-some countries that have signed the UN Convention Against Corruption, have imposed a duty upon ourselves as law enforcement or country to actually prove that's wrong. To prove that, in fact, the intent was a corrupt intent and not simply an innocent intent for some people who are who feel that they need to thank their judge. And so the one comment I would have is that we really need to make sure that throughout the world that sense of or requirement of intent is honored fully in every legal culture, because that does draw a distinction between the favor to someone who you feel you need to thank and the bribe or gift that was given in order to get an official act taken care of. And also, the sense of ethics on the part of the judiciary becomes important because, as somebody pointed out, it's the judge who should know I'm not supposed to take this, even if these folks are, innocent litigants and really want to thank me. I'm not supposed to take this, and I know I'm not supposed to take this because I just went through an ethics class. And I signed a piece of paper to say I was there, and I was awake for the whole thing. And I learned that any gift over $50 or whatever it is, and that can be a cultural thing. I mean, it may be 50, maybe it's 500, I don't know. But the point is, you've got rules in place, and you've got a mechanism to make sure the rules are implemented. Or a way for the prosecutor to prove you just took that class, you can't take over $50, and you ended up with this cow or whatever it was they were going to give him.
I just have a quick observation to add to that, which is you actually mentioned a dollar figure, and I think that's the key to addressing these cultural norms of gift giving, which are adorable. I love them. Why not? But you can only be sure that they're not bribery if it's constrained, right? $50. If it's very, very clear what the code is, that allows for transparency to take place. That allows for the organizations for whom they've made that their business to say, hey, that was a violation, sorry. Because otherwise it's one of the joys of life to express thanks. That's not a bad thing per se. I just want to raise one point which we haven't yet touched on, even though it's close to the end of the session, and that is efficiency. And the need for working with judicial management systems on efficiency and dealing with backlogs, because not only does that help the perception that the law is working for the people and upholding the rightness of the process, but it also diminishes incentives for extra fees for expedited treatment. And so that's a very important thing to do. The ABA is working extensively in the Philippines on an case management program in which we've reduced the backlog on some of the smaller claims cases by 1,000%.
Okay. I think we have still time for one round of questions. So is anyone that would still like to pose a question, or are you all sort of like leaning more towards lunch? There's someone.
This kind of goes back to your question you had a minute ago, but in those of you who've had international experience, what have you seen, or have you seen much efficacy in implementing these international or even nationally created standards? So for example, prison standard, like you get certified for prisons, or creating a law exam. So not just going off, okay, you have a law degree, but you have to pass a bar exam of sorts. Have you seen that actually help raise the transparency standards and the judicial standards in countries?
So that goes to the measurement question too. Like how do you know you've had a success? And the ABA has been doing something called the Judicial Reform Index for a number of years, and in a handful of places we've actually done it multiple times. And it's an index that has 30 factors. It subscribes to it's not specifically focused on corruption, but it's the whole picture. It's all of the features of a healthy, functioning, democratic, transparent, accountable judiciary, all the good things we want and that are enshrined in Bangalore. And so we actually ran this in Armenia 4 times. And this is just, and after having worked in Armenia as well with the bar associations, with law students and judges, and doing extensive trainings and bench books and guides and toolkits and manuals. And in Armenia, after 4 different, I think over a period of like 15 years, the last one was in 2012, and that last Judicial Reform Index that we ran showed us an improvement in 7 factors out of 30. So yeah, we moved the the bar, but it's hard work. It's really hard work, and it's you just have to really stick with it.
Okay. I mean, similar to that experience, we've been also trying to do that, especially in those countries where we had larger judicial reform programs, to have sort of baseline surveys and then follow up actually with every following project to repeat the exercise. And that gave us quite some good insights into both the things that had improved as well as things that have perhaps deteriorated. I think the good news is now that at least sort of on a more macro level, you have now the World Justice Project, Rule of Law Indicator. You have, of course, Transparency International's Global Corruption Barometer, not the Corruption Perception Index, but the barometer. So there are some judicial indicators. Also, the World Bank has its own, the ABA has one. So there's quite a number of indicators that you can now basically create to monitor a little bit on whether you see some improvements. My main problem with that is very often that while the indicators are called whatever the 2017 corruption barometer or whichever other one, when you actually dig deeper, you will find that in the specific country that you are interested in, the last data set basically dates back like 2 years. So you have to look very carefully at what you're actually measuring, and that is not always not always so easy to determine. Are we basically sort of like any last thoughts on the panel?
Yeah, I do have one list.
Yeah, please.
Yes, I'm usually get the list where it's a judge, not always, but sometimes. I just think we should be conscious of the fact that this isn't just about in terms of development of rule of law in different parts of the world, that I think we can take comfort in some of our own travails in this country, meaning that the balance of powers in this country between the executive, the legislative, and the judiciary has always existed. And usually, I'll be over next Friday over at the Federal Judicial Center we have delegations from Georgia and from Serbia, and where's the third country? And I forget. There's 3 countries coming in, and it's right. And I always try to emphasize that this country is founded that way, and there are constant pressures and balances, and that as we work with countries in developing their rule of law concepts, that it didn't happen overnight with us, obviously, but that it's a continuing tension to this day as we speak, even more now perhaps in terms of the independence of the judiciary, and that there's always this give and take, and that it's very important to recognize that, and it's very important that the rule of law is a basis of all that. And in the most blunt terms, it's also very important in terms of the economic development of many of these countries. I can recall being in Russia, when we still had an exchange with Russia, would be very upset about their arbitrage court and how proud they were of it. And they would say, and I politely told them at dinner one night, I said, there is not an American lawyer with a major American international law firm that would not have an international arbitration clause in a contract, because they don't trust your court system. I said, so you're not going to have these companies invest money in this project if they don't have that, because they just could not possibly. And sure enough, the arbitrage court in Russia, unfortunately, has now been absorbed by the Constitutional Court, and the head of the arbitrage court now is teaching in a law school and has been fired. So I'm afraid we were somewhat prescient what happened there. But that's why they're binding international arbitration clauses in major contracts with respect to foreign investment. And I try to always explain to people that it's in your interest to develop the rule of law concept. We all have to deal with this. We still deal with it in America, a balance back and forth. But it's very important to understand that, because in terms of economic investment and development of your country, which you're all interested in, and the standard of living for all of your people, you need to understand that there has to be this give and take. And I think that's important for all of us to remember, that it took us a long time to get where we are. We still have a long way to go. It's always having to improve, but there is this balance. And as painful as the balance can be, it's important for us to understand it, accept it, and I think really be proud of it, quite frankly. So,
excellent. I think that's the best final words that we could have had, so I'm not going to try to add to them. I think we can close at this stage, and any sort of like logistical.
Quick housekeeping.
Yes.
Sorry. First of all, please join me in thanking this panel and our panels from this morning. I'd like to give special notice to Oliver, who as of last night was literally unable to speak, and at 9 this morning wasn't sure, and I begged him to share his wisdom and his experience from UNODC, having come over from Vienna to be with us, so thank you for pushing through this morning. I also this morning did not recognize, as I should have, our team from the Rule of Law Collaborative, who've worked very hard to make this event happen, starting first and foremost with Steve Ostermiller, who really has spearheaded this entire project and from whom you heard recently. as well as our Deputy Director, Hamid Khan, who's in the back, Carol Young, Carmen Jackson, and Kristen McLeod, who are a couple of our law students who work with us, and Lauren Rippey, who's with us today. You've heard mention this morning of bar associations, media, and other non-governmental actors. I want to remind you that our post-lunch panel will address exactly those questions of the role of those actors in strengthening judicial institutions. And then following that, Chief Justice Jilani will share his insights, not only from his experience in Pakistan, but having been here all day, his observations from our day's discussions as our closing keynote. So I hope you'll be able to stay with us through the afternoon. And I remind you that our lunch is really intended as an opportunity for you to network. So I encourage you not only to catch up with people who you know, but to meet new folks who are here in attendance during lunch, and we'll reconvene. If for some reason you do have to leave, I do encourage you to turn in your evaluation forms. I will promise you will be hounded by our team on your way out if you don't. And so we encourage you to give your feedback to us, and we look forward to seeing you back here for our next panel. Our lunch is just across the hallway just now. So thank you all very much again.
You stay for lunch? You staying for lunch?
I am, yeah.